Hey, welcome back to Prepared Overlander. All right, in this one, so I saw something that was really interesting, and I think it could eventually lead to something that's going to go a lot further than just what the ruling was on. So the Supreme Court possibly changed digital privacy, and with the geofence ruling, and so what does it mean? A recent Supreme Court decision could become one of the most important digital privacy rulings in years. While the case did focus on only geofence warrants, the reasoning behind the court's decision could eventually affect everything from cell phone location tracking to automated license plate reader systems, so the flock stuff. Today we're going to break down what happened, what the court actually ruled, and why this case may be only the beginning of a much larger debate over digital surveillance in America. So let's go ahead and get into this. Okay, so what is a geofence warrant? Imagine a bank is robbed. Investigators don't know who committed the crime. Instead of identifying a suspect first, they ask Google, the company, not on your phone. Okay, show us every device that was near the bank between the hours of 1 and 1:30 p.m. Google may have location records for dozens or even hundreds of devices in that area. Investigators then begin narrowing the list until they identify a possible suspect. That's called a geofence warrant. Unlike traditional investigations that start with a person, geofence warrants start with a location and work backwards to identify anyone who happens to be there. Okay, so why is this controversial? The problem is simple. Many of the people whose phones appear in the search are completely innocent. They may have been walking by, eating lunch, working, waiting for a bus, or just shopping. Their location data becomes part of a criminal investigation despite having nothing to do with the crime. Privacy advocates have argued for years that these warrants resemble digital fishing expeditions. All right, so what did the Supreme Court decide? The Supreme Court held that obtaining historical cell phone location information through a geofence warrant is a Fourth Amendment search. So that's a major development. The court rejected the idea people automatically lose their privacy simply because Google stores the information. So in other words, just because a technology company has your data doesn't mean the government can freely obtain it without constitutional protections. However, the court did not ban the geofence warrants altogether. Instead, it said that courts must analyze them under normal Fourth Amendment standards, including probable cause, particularity, and reasonableness. That means future geofence warrants will likely receive much closer scrutiny than they have in the past. Okay. Why this matters beyond Google. Here's where things get really interesting. The court wasn't only talking about Google. It was talking about location data. Modern life produces enormous amounts of location information. Your phone, vehicle, your smartwatch, navigation apps, fitness trackers, connected cars. The court recognized that location history can reveal an incredible amount about a person's life, where you work, where you worship, where you visit, what doctors you see, what political meetings you attend, and a lot more. Could this affect license plate reader systems? This is where many legal experts believe the next big constitutional fight may occur. Automated license plate readers, or ALPRs, capture photographs of license plates as vehicles drive past. One camera reading your plate is generally not controversial. Anyone standing on the roadside could observe the same thing. But today's systems often involve thousands of cameras connected through large databases. Instead of asking, did this camera see this vehicle? Investigators sometimes ask, where has this vehicle been over the last several months? That's a very different question. The difference between observation and tracking. Think about this. A police officer sees your vehicle drive by. That's ordinary observation. Now imagine thousands of cameras documenting your travels every day, 1 week, maybe over months, or over years. Those records can potentially reconstruct your routines, habits, and associations. At some point, the issue is no longer a single observation. It's long-term tracking. That's the constitutional question courts are increasingly confronting. What about systems like Flock? Many communities now use an interconnected ALPR systems that allow participating agencies to search historical records. So current law generally permits many of these searches under existing legal standards. But after the Supreme Court's Geofence decision, attorneys challenging long-term ALPR searches have a strong constitutional argument than before. The key question may become, when does searching a massive historical location database become a Fourth Amendment search requiring stronger legal justification? The Supreme Court hasn't answered that question yet, but this new decision makes it much more likely that this issue will eventually reach the court. Okay, why is this important? Technology has advanced far faster than privacy laws. Years ago, tracking someone continuously required teams of investigators. Today, computers can often reconstruct movements in seconds using historical digital records. The Supreme Court appears to be recognizing that constitutional protections cannot simply disappear because technology makes surveillance easier. That's likely to influence many future cases involving digital privacy. Okay, so final thoughts here. Whether you support stronger law enforcement tools or stronger privacy protections, this case represents an important shift. The Supreme Court did not outlaw geofence warrants, but it made clear that obtaining this kind of location information is subject to the Fourth Amendment. That single principle could influence future cases involving automated license plate reader databases, other historical location records, connected vehicles, emerging surveillance technology, large-scale digital tracking systems. We'll have to wait and see how lower courts apply this decision and whether the Supreme Court eventually takes up all ALPR case. One thing is certain, the conversation about privacy in the digital age is far from over. If you found this breakdown helpful, consider subscribing and sharing this video with someone interested in constitutional rights, technology, and preparedness. Thanks for watching. See you in the next one.